Hello, my name is John Lentz, and I'm an attorney at Lepant and Lentz. We're a Nebraska law firm serving eastern Nebraska, primarily in the area of bankruptcy. Today I'd like to talk about some considerations with respect to tax refunds and filing bankruptcy. It's the beginning of a new year, and according to the law, you now have an expectancy property interest in a potential tax refund from the IRS and the State Department of Revenue. Now, why would this matter? Well, if you're filing bankruptcy prior to receiving your tax refund, you must disclose the interest in a potential tax refund as an item of property in your bankruptcy schedules. Now, sometimes people have very large tax refunds, which then becomes an issue if that person files a Chapter 7 bankruptcy prior to actually receiving that refund. In a Chapter 7, as you may know, you can lose property. So what should you do? Well, all property interest of a debtor who files bankruptcy can be exempted from the bankruptcy estate subject to limitations set forth by law. In Nebraska, you have the ability to exempt $2,500 of personal property, and in addition, any amounts attributable to the earned income credit are exempt. Exemptions essentially prevent the trustee in a Chapter 7 bankruptcy from being able to take your assets. In a Chapter 13, exemptions prevent you from having to pay unsecured creditors. So the best indication of what your tax refund may be for this new year if not much has changed since your last return, is by looking at what you received in a tax refund for the prior year. That may or may not be a good gauge, but it's at least a starting point. This will give you an indication of whether or not you would lose your tax refund if you file bankruptcy before you receive it and you receive the same amount as you did last tax year. You'll certainly want to consult your attorney through all of this, but what do you do if you stand to receive a large amount in a tax refund but you're wanting to file bankruptcy? Well, timing is everything, as they say. For example, let's say you're single and you expect to receive a total refund in the amount of $5,000, but none of it is attributable to the earned income credit. In that case, if you filed a Chapter 7 bankruptcy before receiving the refund, you'd lose a portion of it because you cannot exempt it all. If you filed a Chapter 13 bankruptcy before you received it, then you wouldn't lose it because you don't typically lose property in a Chapter 13, and the worst that could happen is you may have to pay a little bit of money to your unsecured creditors in the future and at no interest. In this example, if you wanted to file a Chapter 7 bankruptcy, you'd be best served to wait until you receive the refund and use it for your everyday living expenses until it is spent down to an exemptable amount. It's best to consult with your attorney about how you should spend your tax refund, as some uses may not prevent you from losing property in a Chapter 7. Of course, if you have further questions regarding tax refunds and filing bankruptcy, please feel free to give me a call at 402-421-9677.